Okay, today is the 27th day of February 2017. My name is Wes Christian. I'm here along with my colleague, J. Paul Manning. The two of us are on the litigation council of the State Bar of Texas and are here to interview Tom Morris's life as a lawyer. We're here today after Mr. Morris has been unanimously elected by our litigation council members to become a Texas legal legend. 10 years ago, the State Bar of Texas, through the Litigation Council, started a program to begin to teach law students and lawyers how to reclaim the reputation that unfortunately we have obtained in the last 30 or 40 years. And in doing so, teach young lawyers and existing lawyers what a real lawyer looks like. Today we're here to hear Tom Morris's story. Why? Because he represents everything that a lawyer stands for. He has an exemplary life as a lawyer and adheres really to the same values that the Litigation Council, through the Legends program, decided it was going to adopt. Those principles are understanding really that lawyers are the gatekeepers of justice in this country, and that they have an absolute duty and a most important duty, and that is to take something that's wrong and make it right. Take something that's evil and stamp it out. In doing so, that requires a lawyer to make great sacrifices, sometimes to his finances, sometimes to time with his family. Certainly occupies a lot of time, and sometimes even to their personal safety, because there is evil out there in the world that is ever present. And frankly, the only people that can do something in stamping it out is lawyers, because we're the only profession who can file a lawsuit and change something. And the reality is there have been, for the last 240 years, an enormous group of lawyers that have taken on incredible tasks that benefited the lives of all of us. Whether it was Abraham Lincoln who abolished slavery, or whether it was Alice Paul, who was the person who was in the forefront of the women's suffrage movement, who passed the 19th Amendment giving women the right to vote, or Thurgood Marshall in desegregating school districts, or recently the lawyers who took on the National Football League for hiding concussions, or the other lawyers that took on the Catholic Church for abusing boys for years and years. And so, Mr. Morris, we're here today really to honor you and learn more about your life. You'll be inducted at a later date at Texas Tech University that agrees with your schedule, in front of the entire law school class and all the people that you want to invite and many other distinguished guests. But our purpose here today is to really learn more about your life, knowing that it fits into the very thing and the reasons for which you got inducted. And I'd like to just open it up and start with you telling us, about your life, how you initially became a lawyer, and anything else you want to talk about.
Well, the first thing I want to say is I'm deeply humbled by this election and this opportunity. I've had way more than my share of success in a lifetime in the profession, but I'm humbled by this award. I've had more than my share of awards, but this probably tops the list. Now, I think there's something that would be interesting to everybody, is how did I ever get into the law practice in the first place? I grew up in a little country town called Maypearl on the International Great Northern Railroad south of Fort Worth. My father was the depot agent, the telegrapher, the freight agent, the express agent, the whole works. I had 5 siblings. I had 4 brothers and one sister. We all worked. There wasn't anything no type of employment except agriculture. We picked cotton, pulled corn, shocked hay, did every kind of thing that you could do. Well, in high school, in school I was a pretty good student. I made 1B in 11 years of school, and that was in deportment because I got caught throwing spitballs one day. But my favorite subject in high school was physics. I just loved physics, and I loved algebra, trigonometry, those, and math. I just love math. So I thought I wanted to be a physicist. when I graduated from high school, I was valedictorian, and I went up to North Texas, NTAC we called it, which was a junior college branch of Texas A&M, and I set out to be a physicist. Changed my career pattern. Decided I went into studying business instead of physics and that sort of thing. Well, that didn't excite me too much. I thought, well, how about law? And he said, I think that's a good choice for you. I think you'd be a good lawyer. So that's what I did. I went down to university. I finished 2 years of junior college. Went down to the University of Texas to see whether I could get into law school. It only required 2 years of junior college then to get into law school. I went in to see Dean Hildebrand, who was a great big old country West Texas cowboy type, but he had built the law school into what it was at that time. And I interviewed him personally. That's the dean of the law school. And he said, when we finished the interview, he said, Mr. Morris, so you meet the requirements, but I sure would recommend that you go back up on the hill and get your degree, because you don't have much chance making it. And I said, Dean, I want to get on and start making a living. So I entered law school. That year I worked at 2 or 3 different jobs to make it through, but I made top-notch grades. I was right at the top of the class, and the next year I was Dean Hildebrand's quizmaster. so that was a pretty good little change to start off with, and I went on through law school. I made chancellors, and then I was in my senior year when World War II came along. I'd been up to Dallas and then enrolled in the Navy Air at Thanksgiving holiday. I got a deferment until I could finish my law degree. Then Pearl Harbor arrived the next Sunday after I got back to UT, and on Thursday the Navy Department says you'll report for duty for January 2nd. We can't honor your deferment.
And what year was that?
January 1940. January 2, 1942. So I reported for duty, had the elimination school, and passed we got 15 hours instruction, got 10 hours of dual and 5 hours of solo, and passed, and then went to Pensacola, where I entered the flight school, and went through all of the primary training, the intermediate training, the instrument training, and all of that. Got my wings in November 1942. I survived a mid-air collision at about 5,000 feet. Flew the plane thought I could land it, flew it through the pine trees, and spent 6 months in the hospital following that. And after that, I went back to the flight school, took a little refresher, taught primary and taught instruments for about 100 hours, then got a squadron assignment. We organized Air Group 80 beginning in December 1943, got the squadron all organized. I was going to be a dive bomber. So we commissioned the Ticonderoga, went to the Pacific, spent nearly 2 years in the Pacific. Got out of the war. When the war was over, I flew F-6s. I flew Helldivers to start with as a dive bomber, and then shifted to fighters when the kamikaze situation developed. We checked out they cut the dive bombers half in two, and we added fighters, and I checked out as an F-6s. Qualified on the old Saratoga. Beautiful, beautiful, old wonderful ship that had been salvaged from early days when it nearly was lost. Its co-ship was Lexington, the old Lexington, which was sunk in the Coral Sea. But anyway, I went back to the fleet then as a fighter. That's what I flew the rest of my life. And at the end of the rest of my career, I was flying the famous Corsair 4U4 fighter bombers. But anyway, the bomb was dropped when we were getting ready to go back for our second tour of the Pacific, and that was the end of it as far as I had enough points to get out immediately. I got out on the first muster, got back to law school just in time to get into, they were on a 3-year term. I got it back just in time to get into the term that started the 1st of November. I finished my law school, and this, I hate to keep talking about this, but that was the easiest year I ever had in my whole life as far as law study was. It was just easy. I made all the honors you could possibly get. I made order of coif. I got the award for the best legal argument in writing, and a set of black statutes as the prize, and so on. Well, immediately after graduation, Dean McCormick, who was one of the most genteel people that I've ever known in my life, he was the dean, and he came in and called me into his office, and he said, "Tom," said, we'd like to hire you as an associate professor to start teaching in the fall." Well, of course, they were dragging the bottom of the barrel at that time. We had the GIs, the soldiers who were coming back to law school. Everybody wanted to get in. We had classes like 125, 130 students in a class. But so I was flattered that I would be selected to go on the faculty, but I did. And I taught 2 years. I taught torts was my primary course. I taught a course in property law. And then Dean McCormick came in one morning and said, that was my 2nd year, he said, "Tom, I want you to organize a seminar in legal argument and writing." I said, "By God, Dean, what am I going to teach? We don't have any textbook or any case book or anything." He said, "Well, it's up to you. I'm going to let you organize the class, and you do what you want to do." So I enlisted the aid of district judges, the Austin Court of Appeals judges, the Texas Supreme Court. Judge Hickman was the Chief Justice at that time. They all jumped in to help me on what was important. So I organized a course in legal argument and writing and taught a seminar. That was the first time it had ever been taught at the University of Texas. At the beginning of my 2nd year, University of Texas established, this was in response to the Sweat case, which had been tried by Thurgood Marshall there in Austin, and Price Daniel was Attorney General, and Joe Greenhill was his first assistant. So they established an equal but separate law school. And I was selected to teach a torts class to that equal but separate law school. We had 3 law students. We had 1 lady and 2 men. The girl, I don't know how she ever got through high school, but she did. But she flunked out the first semester. The other 2 made it through all right. One of them made a real good lawyer in Houston. So that was my experience. During that course, I got to be good friends with Joe Greenhill, but he was first assistant attorney general, and I was teaching over in that law school. We'd get together and have breakfast and discuss. Got to be good friends with Joe Greenhill at that time. Well, after 2 years on the faculty, I really and truly became a little disenchanted. Teaching it was great experience. I made hundreds of friends, but it wasn't what I wanted to do. I wanted to be a trial lawyer. I taught torts and I taught some procedure, and so that just fascinated me, and I'm a natural born competitor. So I want to get in the pit with the rest of them. And incidentally, do y'all know where the term a pit fighter came from?
I do not.
It came from Old Bailey. And I got to, later on, I'll break this in later, I got to go to Old Bailey in London some years later. And you may think of Old Bailey as one courtroom. Well, Old Bailey is a 32 courtroom building, but all of the courtrooms are built like a pit. The barristers are all down into the bottom of the pit around a table, and the witness stands up up on a stool in a cage over to one side, and my lord sits up on a bench way up above it all. Well, the barristers got to be known as pit fighters because they were waging their battle from the bottom of the pit. So that's what I wanted to be, was a pit fighter. So, and then the second thing that happened was that some of those teachers, those great teachers that I had just worshipped, I mean, they were heroes. Smart people like Stillberg, Judge Staten, and Judge Walker, Buck Bailey, and Judge Wicks, and Leon Green. I got to be on the faculty with Leon Green as teaching torts, both of us teaching tort and so on. So, but it turned out that some of those heroes had clay feet. They were just ordinary human beings. A couple of them nearly got in a fight one day at a faculty meeting, and one professor invited the other one and said, just come out in the hall and we'll settle this out in the hall. So I didn't like that too well. And then the pay on the faculty wasn't too good either. It's $400 a month. So in Harlingen, I went to Harlingen with a good friend of mine. He was a student of mine, but he was also a good friend. We played the golf together, played with a couple of other great golfers, the couple of city champions and so on. So we formed a partnership and went to Harlingen to open a law practice. Well, it turned out my partner was a golfer, not a lawyer. He was a lot more interested in playing golf and playing gin rummy than he was practicing law. So that didn't work out too well. So we decided to leave the valley, and the valley had a bad freeze that year, froze the citrus crop and the vegetable crop, and it was depressed. We got in the car and drove around, and I didn't want to practice in Houston, Dallas, Fort Worth, San Antonio. I turned down jobs when I graduated from law school like that, but I wanted a smaller town, so we just drove around till my wife came from Spearman up here north of Amarillo, and we decided Amarillo was a good place to settle down. So didn't have a job. The firms weren't hiring, so but there was a lawyer here who had a ton of old subrogation cases. He wasn't a very good lawyer, but he had a stack of old subrogation cases. I couldn't get a job with any of the firms. So he said, I'll just give you this stack of cases. You can go to work on them. I can't pay you any salary, but you can just you can share half of what you make out of those cases. So I started trying those old cases. I got one or two that had a little merit to them, made a little money on the side, but it wasn't any place to be. And so I started trying lawsuits and started making a little name for myself, got known in Amarillo. And so I was hired by the Gibson firm April 1, 1950. Went to work for the Gibson firm. Joe Harlan was their lead trial lawyer, and he was absolutely smothered with work, had more than he could possibly do. So I had a stack of cases to defend, all defense cases, immediately when I got in the law firm. So I just got off the ground running. I started trying lawsuits, just lawsuits after lawsuits. But the first case outside the tort field was an antitrust case, a small antitrust case, one of where the company agrees to sell all of its product an exclusive, and I contended that was a antitrust breach, and we lost it in the trial court. Took it up, and the Supreme Court granted a writ of error, and I was the petitioner. Granted writ, and went down there and argued that case before the Supreme Court. My opponent, my people here were Senator Grady and his young lawyer. My opponent in the Supreme Court was Judge Black of the famous Black and Staten law firm in Austin. They were the best appellate lawyers that ever existed, I guess, down there. Judge Black probably tried more cases, argued more cases in the Supreme Court than anybody until Jim Kronzer came along some years later.
Mr. Morris, what year was this?
1952.
Okay.
It just took a year. I tried the lawsuit here in Amarillo and went to the Supreme Court. Got it to the Supreme Court in less than a full year. The appellate time was just like that. Court of Appeals heard the case promptly, affirmed the trial court, and of course the Supreme Court affirmed it also. So I learned right quickly that first place, you better take a good look at your case before you go to the Supreme Court, because no point in taking one down there that you can't win. And then particularly when you face somebody like Judge Black. But that's what a rare experience that was, to argue my first case in the Supreme Court with Judge Black as my opponent.
Wow.
Judge Hickman was the Chief Justice. And an interesting little story, when I got to be close friends with George Stonewall, the professor, I asked him one day what he thought about Judge Hickman as an appellate judge. He said, "Tom," said, "I probably ought to say this, but as an appellate judge, he's a good Sunday school teacher." So I kind of always felt that way about Judge Hickman's cases. Worked the most depth in law. But that was my beginning. Where do you go from there? I started trying lawsuits for the Gibson Law Firm, just case after case after case. I could tell you most of it was tort cases to start off with, defense, mostly defense. Occasionally we'd have a plaintiff's case, but by and large we were defense attorneys, and that's what we did all just day after day after day. And so I set out to become the best defense lawyer I could possibly be, which meant to learn everything there is: substantive law, procedural law, evidence law, a little psychology on how do you select a jury. So you have, I learned a good lesson down in Harlingen. First jury case I tried was in Harlingen, in Brownsville. The county seat was Brownsville, Cameron County. Selected the jury, and I had a pretty good client. He was a passenger in a taxi cab. The taxi cab ran a red light, got hit broadside, severed my client's ulnar nerve. So he wound up with a claw hand, with two fingers claw hand. So I took that case as a plaintiff. I won't tell the whole story, but I didn't seem to be able to get any response from the jury. As we went along trying the case, nobody was reacting to anything that I said. I had my client on the stand telling what a difficult time he was having. He was a manual laborer. He couldn't make a living. It kept him worried all the time. And one big juror sitting back up in the corner began to nod his head. He had to nod his head. I thought, well, by golly, I've got one. The jury was hung. It was out. We tried it for over a week. A small little tort case we tried over a week. John Quincy Adams was a good defense lawyer on the other side. He was very kind to me and kind of helped me stumble through some of the things that I was trying to do. But the jury was out. It was hung up when it's time to go home on Friday evening. They just told the court they were hung. The judge was a new judge, Arthur Klein, who was a very, very good judge, but he was a brand new judge and he doesn't really know what to do. So he asked them if they thought they could reach a verdict, and they said, well, maybe we don't think so, but maybe so. He said, well, what I'm going to do, I'm going to put you in the dormitory and I'm going to let you stay overnight, and you all can work as late as you want to. Only time in my entire career that a court has sent the jury to the dormitory and sequestered the jury in a civil case overnight, but he did. And as my partner and I were, at that night, we were wondering what the jury was doing, so a juror would come to the window and look out, and then another juror would come to the window and look out, and they weren't making any progress. But they returned a verdict the next day about noontime. No, wrong. No. let me back up just a minute. They never did get a verdict. And after when we examined the jury, they were hung 11-1. The judge asked them how they stood. 11-1. The one man that I thought was on my side, there was one hang-up that did not go with me. So my attitude was, you got to learn how to read a jury. You can't always tell what's going to happen before a jury.
Well said.
All right, now then, let me kind of refocus here just a little bit. So we tried every kind of case there was. You just learned how to try every kind of case. You'd shift. You have to learn new substantive law. You have to new evidentiary law, and so it kept you working all the time. It's a never-ending task, and to be a good lawyer, anybody's got to know that it's a never-ending task. It doesn't just come naturally. You got to learn the substantive law. You've got to learn the witnesses. You've got to learn the technology involved. You've got to learn if there's sociological problems involved. You've got to learn expert witnesses. You've got to do all of those things, and not just do them. If you want to win, my attitude was that I must know more than anybody else in this courtroom about this case. Every facet of this case, I must know more than anybody else in the courtroom. So that's the way I tried to prepare cases. Building notebooks, I started building every facet of the case to take care of it. So it turned out to be a pretty successful way to go about the practice of law.
Did you start with the jury charge and work backwards, or?
No, I never did. That's what Judge Staten used to always talk, is go do your jury charge and work backwards from that. That's wrong. That's wrong. You've got to know what the case is about. First, what do they plead? What is it that they have pled that I'm going to have to meet? So I don't want to go build that case before then on stuff that may never come up. So I didn't do it that way. I waited until I had studied the law of the case. I determined what the plaintiff was doing, what his theories were, what his allegations were, what his claims for damages were, and what it was I was going to have to meet in that case. And that's what I prepared for, not from a hypothetical charge that I built it toward. I don't think that does any good. That's the one thing I always disagreed with Judge Staten on. But I've handled way over 1,000 cases. We used to handle in the days when we had automobile and insurance cases, we'd announce ready every Monday morning, almost, in some county in the Texas Panhandle of the South Plains. We'd be ready. Of course, that wasn't a big, tough body of law in those days. Tort law and workers' comp law wasn't tough stuff at those days. You could learn that, so you could try a case every Monday if you wanted to, and 9 times out of 10, you'd start the case, and plaintiff's attorney would say, let's try to settle this case. We'd settle them. Well, a lot of them didn't settle, and so.
Well, one of the examples when you and I tried a case in Tulia, Texas, I was so impressed that we had hired an expert in that case, and you didn't even hire a counter expert, and you complimented our expert in that case. And I remember thinking how classy that was, because you could have run up fees, expenses for both parties, but you said, man, this expert is right on. We'll agree to that. I was so impressed with that.
Why should we argue that the plaintiff is not hurt, for example, when all you got to do is look at him? Anybody knows that you can't win a lawsuit in the first place, and in the second place it's wrong. Now, if you've got a good point of law, a good point of evidence, some good facts, that he's not, yes, he's terribly hurt, but he's not entitled to recover, then that's the kind of case that needs to be tried. But it needs to be tried straightforward with the facts like they are, and not trying to patch something up that doesn't exist, not criticizing an expert when an expert. On the other hand, if an expert is not an expert. He needs to be torn to pieces. And it takes a real skill. Learning how to cross-examine an expert is an art. Well, it's not just an art. It's a hard work. You've got to get so you know more than the expert does. And you've got to know how to ferret out the weaknesses in his testimony and how to bring it out. We had a big case involving a lot of money over in the Anadarko Basin, involved about 6, 7, 8 wells, deep borrow wells that were a lot of money. Well, the contest was over whether my client was doing what it was supposed to do. And they had an expert the other side had an expert who was a nice person. And he was a good expert as long as he stayed within what he knew. But he ventured beyond what he knew, and he didn't have any factual basis to support his opinion. But the expert was honest as he could be. And I finally got from him, I asked him this question. Said, I understand exactly what you're saying, but do you really have any empirical data on which to base your opinion? He said, no, I don't. I don't have any. It's just my opinion. I think that's what happened, but it's just my opinion. I can't support it with any facts. Well, I got that square, direct admission, and the Supreme Court pointed that out when we got to the Supreme Court.
What do you think, Mr. Morris, is some of the most important cases you've handled that really benefited others or made some good law for the benefit of society or for companies, that type of thing?
Well, unquestionably, I'm glad you asked me that question, Senator. Unquestionably, the high point of my legal career from a trial of cases is concerned is Graham versus Deere, the famous patent case which I argued in the United States Supreme Court in October 1965. Supreme Court handed down the opinion the following February in 1966. I won the case hands down. But the issue was the proper interpretation of Section 103 of the 1952 Patent Act. Now, that was a new section that was put into the Patent Act in 1952. It was called the obvious or non-obvious subject matter was the broad form name of it. The circuits had gone every direction in the world. For nearly 13 years, the Supreme Court hadn't written on it. The entire patent bar of the United States, and judges as well, and professors were all waiting for a decision by the Supreme Court. So while ordinarily the Supreme Court, when the benches are all full, they don't let anybody stand around the court, the Supreme Court granted lawyers, they came from all over the United States, patent lawyers and so on came from all over the United States to hear those arguments. And the court permitted them to stand all the way around, clear up to nearly to the bench, all the way around the sides of the courtroom and at the back of the courtroom. So we probably had 200 people, 200 lawyers and professors and so on, in the audience to hear that case. So it was a magnanimously important case, extraordinarily important case. Here I was, a little old country boy that started off 10 years before. I didn't even know what a patent was. So a little bit, but anyway, I won a lawsuit. But let me tell you the two interesting things that occurred during that day. That Thurgood Marshall, who had tried the Sweat case in Austin, I'd seen him tried in Austin trial court, argued his first case as Solicitor General. He had the first case on the docket that day. So Thurgood was there to argue that first case with his frock coat and all the dressings and what I call a lackey to carry his briefcase. But he argued that first case, so that was a real experience. But the more important dramatic thing that occurred during, well, two things. Number one, when I was making my argument, Judge Black, who's a little smaller than I am, he sat down back at his big old chair, and you could just barely see his head over the bench. And as I was making my argument, the other side had made a big pitch about a particular function that they hadn't argued before the patent office, and Judge Black raised up. He kind of stood up like that. Said, "Mr. Morris," says, "what difference does it make?" I said, "Your Honor, that's what I've been preaching for 10 years. It doesn't make any difference." "Oh, that's what I thought it did." Well, I didn't have to worry too much about the rest of my argument, so I cut it pretty short. I had a major case down in Scurry County. A family, a wealthy family. The man had built a good ranch down there in Scurry County, and in 1949 the drilling was beginning to develop. After World War II, drilling was beginning to develop. He had a ranch of about 18,000 acres or so that he'd put together in Scurry and King County. Well, the people wanted to lease his land. And he said, "Well, I'll sure lease it to you, all right, but I'm going to tell you where you drill the first well." Well, the geologists, the people who wanted to drill, said, "My God, we can't do that, but we'll take your deal." See, and he didn't. He wasn't too bad on a royalty. He had a 3/16 royalty when the standard was 1/8. But he said, "I'm going to tell you where to drill the first well, and you're going to drill it before the year's out." So he drove him around the ranch and said, "Here's where I want it. There's an outcropping over there, and right here is where I want the well drilled." And the geologist shook his head and said, "No, that's completely off structure as we have the geology mapped. You're completely off structure." Well, they drilled the well, and they hit a new formation called the Cogdal Canyon Reef. Had nearly 2,000 feet of producing formation. And the well came in at 2,000 barrels a day. And when I got to represent, that was in 1949, when I got to representing the family in 1972, that discovery well was still producing 2,000 barrels of oil a day. Just fantastic. Well, the family got so rich, all they could do is fight each other. So there was two sets of the family. The old man had a first wife, and he had 2 children by that wife. Then he had a second wife and 3 children by that wife. So naturally, the two sides they split up, and they got to fighting over the money and fighting over the money. And another lawyer started off, there were 3 on this side, there's another lawyer here in Amarillo started representing them. He couldn't get along with them, and he finally called me one day and asked me if I'd talk to him, and I said, "Yeah, I'll see him." So I hired out to them, and we got along pretty well. But he hated his half-brother so bad, they got in a fist fight when we were taking depositions down in the courthouse. We were taking depositions in the courthouse. So we had to get a protective order, and Judge Starley, who was on the bench at that time, if you can imagine, supervised the taking of depositions as long as either of these combatants were involved. So the judge sat there with a bailiff, with a loaded, or a deputy sheriff, I forgot, with a loaded pistol on his hip. The next time we assembled for depositions of those 2 guys. And then the other half brother, I was winning most of the battles, and the other half brother bought we were waiting on the law. And the other half brother bought the entire national reporter system, the black statutes and the federal statutes, and set up his own law library. And he said to me one day, he says, now, you write those things in the briefs, I'm going to be able to tell the court whether you're telling the truth or not. Every case I've ever handled, every case I've ever tried, I've tried to learn something about either the law or social psychology or whatever it is. I've tried to learn something from every case. We had this case up in Dalhart, the will contest case. Old Cowboy had built about a 6,000-acre ranch up in Dalham County. But he moved up to Wyoming and put together an 85,000-acre ranch up there. He had 3 sisters, one of whom had helped him along when he was organizing his first ranch, and under his will he gave about 90% of his estate to her and about 10%, well 10% each to the other 2, gave her 80%, 10%. Well, they defended on the ground that the old man was incompetent. He did strange things, like he lived out by himself in his own shack, and he'd eat spoiled bacon, and he'd go into town and side up and go into a restaurant. Somebody be eating a hamburger, and they'd leave half of it, and he'd sidle down and eat the rest of that hamburger. So he was kind of strange. He's kind of strange, but he put together this really, really great ranch that's worth hundreds, well, millions of dollars in those days. And they contested on incompetence. And the chief witness, the star witness, was a Baptist preacher up there in Wyoming, where he lived. And the Baptist preachers agreed to testify that he was incompetent. And the reason he was incompetent is because he didn't believe in Jesus Christ. That was his expert opinion. He didn't believe in Jesus Christ. Well, we had discovered that the old man had just given his Baptist church $10,000 the year before he died. So I asked the preacher, I said, well, you say he was incompetent because he didn't believe in Jesus Christ. Well, did you think he was incompetent when he gave you that $10,000? And the jury just burst out laughing. Well, we won that case. So, let me go back to our basic premise of professionalism. And when you start talking to young lawyers, what do you tell them about professionalism? Well, what do you mean be a professional? Well, your first duty is to the law. First duty is to the law, because if you can't practice the law within the law, you don't deserve to be a lawyer. Your second duty is to your client. So you've got to be honest with your client. You've got to get your client's story. You've got to decide whether he's correct or incorrect. You've got to build, if you're going to take his case, you've got to build a rapport and a confidence with him. That's all part of professionalism. It takes representation of the client and respect for the profession, respect for the court, and never digressing from those three principles. And that's what I tell young lawyers. If you're going to be a lawyer, here's the first 3 things you've got to do. Now, fourth, and this is just a matter of put them in order. The fourth is you absolutely must study the case. You must know the case. You must be entitled to go into the courtroom and represent your client. And if you're not willing to devote the time, the long hours and so on, that's necessary to do those things, then you shouldn't be a lawyer. You should go do something else.
Right.
Now that's professionalism. That takes all of those things to be a complete, well-rounded lawyer. Okay.
Mr. Morris, just kind of summarizing some of the things that you've talked about here today, one of the things that causes problems is when the other side or the other lawyers aren't prepared. Is that something that you've seen happen over the years?
Sure.
We've talked about maybe some lawyers don't succumb to the fear of losing that client and maybe do something that they shouldn't. And that's developed over the last couple of years.
You just can't do that. If you get afraid you're going to lose and you do something wrong because you're afraid you're going to lose, then you just abandon your profession. Right. So you can't do that. Nowadays, discovery. Let me talk about that just a little bit. Discovery has become an absolute impossible burden for clients to bear. And lawyers who don't give a damn, or who don't care about how much of their clients' money they spend, they'll set out to discover every piece of paper, every potential possible witness that might even have the remotest idea, and will send young lawyers out to do discovery, to discover thousands and thousands and thousands, hundreds of thousands of pages of documents, when they're never going to use 10% of them. If they use 1% of them, I'd be surprised in most cases. They could take the deposition of every witness who even might even have a thought of knowing something about the case, when they know that he doesn't have anything important, yet they send the young lawyers out by the herd, by the swarms, literally, to do discovery that they're never going to use. Well, why? Money. Clients' money. Well, that has, in my view, that's just broken it's destroyed a lot of trial practice. It's destroying the law. It's destroying clients. It's making it so that clients don't want to try cases because they know that it's going to cost them such a fortune when they go into it that they can't do it. So what do? They roll over and take an unacceptable settlement, pay 10 times as much as they should pay as the case is really worth. Why? Because it's going to cost them that much to defend themselves. Well, when the profession reaches that point, it's beyond a profession. I'm dead certain it's beyond a profession when it reaches that point. Electronic discovery now. It's fantastic. You have to have expert computer people first to even know what to go after and to set up the programs and go after this and search every nook and cranny of a client's business when they know good and well it's not anything there to start with. Well, maybe I'm overdoing it, but I don't think so. I think modern discovery is causing clients not to come in and be represented, not to come in and try cases. They roll over and say, well, I can't afford to go any farther. Let's get it settled. Well, that's not justice. And the purpose of our profession is to see that justice is done.
And don't you think, Mr. Morris, that massive discovery that it seems like is in every case, on each side, also causes the time period by which a client can even get justice to be enormous? I mean, I have cases now that is 6 years, 7 years, 10 years on the docket, crazy periods of time where some of the clients have died. I mean,
sure.
So to me, don't you think it's such an injustice to allow cases to go that long? You shouldn't have to wait 3 years, 5 years, 10 years to try a case.
And we lawyers, I say we lawyers, I don't take any blame for that, but lawyers have done that, and courts have permitted it, yes, and are permitting it.
Yes.
Now, courts are not doing their business when they let that situation develop so that a client can't come in and present his case some way so that he can afford to get justice. Now, that's wrong. It's wrong from the judicial standpoint. It's wrong from the lawyer's standpoint. And it needs to be rectified, in my view.
Yeah, and I've also noticed in cases we've handled at my firm that especially the cases in New York and other jurisdictions, that there'll be 20, 30, 40 lawyers on the other side and three of us, and then the motion papers that come in. I mean, they'll file enormous amounts of motions, most of which are ridiculous. They're ridiculous. Recently, in a case we had, the lawyers objected to every line and every page of every deposition, including their own client's depositions, including their client's name.
Sure.
Okay.
Well,
Don't you think that something needs to be done about that?
Yeah, absolutely. That's wrong.
It's wrong.
So, sure. So,
Mr. Morris, we talked a lot about how the courts have changed a little bit. Let's talk about a little bit about your personal like apprenticeship or mentorship of other young lawyers. I know in this area of the law you've been tremendous, and I'd like to hear your take on how you train them.
well, a young lawyer comes in, if I happen to be the one he's assigned to, first thing I'll start off with, let's see where we are, and let's see where we want to go. And then here's, let's kind of think about a goal. What do you want to do? And then let's examine what's involved if that's what you want to do. And if he wants to be a trial lawyer, then I can take him right through the steps of what we've been talking about here today. And to do that, to start off before he ever turn loose to go do anything, is okay, here's where we are. All right, first thing now, do you really know the basic procedure in a courtroom? Do you really know the basic evidence rules? Do you know have an idea about how to protect a record? What do you have to do to protect a record? No. Well, how are you going to practice law if you don't know those? How are you going to try lawsuits if you don't know those things? So the first thing you got to do is go open the rule book. You got to go open the Texas Remedies Code. You got to read the Remedies Code. You got to read some appellate rules. You got to read some evidentiary rules. You got to learn what it is, so that when you go over there and now it's ready for your first trial, you're going to know what you're talking about.
We've seen, Mr. Morris, that the law schools are spitting out a lot of students, and a lot of them don't have an opportunity to have a mentorship.
They're spitting out law students that don't know, I'd say, come here from Sikkim. And I've become disenchanted with my old alma mater, the University of Texas, because it has gone away, completely away into the ethereal international law. Well, how many people are going to practice international law? Very, very few. What they need to talk about at the University of Texas is teaching young lawyers how to practice law in the state of Texas. Whether they're going to be a transactional lawyer, a contract lawyer, a family lawyer, a tort lawyer, whatever it is, the schools need to be teaching them that. That's one reason Baylor has had so many good, successful trial lawyers come out of that law school, because they focus on what it is you're going to be doing when you get out to practice. That needs to be redone. Okay.
One of my favorite stories, Mr. Morris, is you telling us about a young associate that you had at one time that might not have been cut out for litigation. Would you mind telling us that story again?
Oh, well, I just hate to tell over and over personal stories. There's so many of them. But yeah, I had a young lawyer who came to us. He was been a bank officer and was as a lawyer, and a qualified lawyer, well educated, and he thought he wanted to be a trial lawyer, and so he came over, and I came in. I was the one going to be his patron and mentor, and got him started, and he started trying lawsuits, and I was doing a credible job. I would say not anything special, but a credible job. And he came in one morning, and he said, "Mr. Morris," I've made a bad mistake. He said, "I'm not cut out for a trial lawyer." And I said, "What's your problem?" He said, "Well, I'm frightened to death. When I go over there to announce ready for trial, I'm just shaking in my boots. I'm not ready for trial. And I'm just scared." And I said, "Well, you ought to, let me tell you something about being scared. So you ought to be over in a 70-degree dive, going to drop a a 1,000-pound bomb on a ship, and with anti-aircraft busting all around you, and you'd have a reason to be scared. So. Let me tell you, and this has to do with professionalism. I represented the Cogdell family that I mentioned a while ago down in Scurry County. And after we got most of the case settled, my two clients wanted the old folks that put part of the estate in trust with the Fort Worth National Bank as trustee. And my two clients wanted to sue the First National Bank as trustee on the ground that they had breached their fiduciary duties and had to spend a lot more money defending the cases than they should have, and so on. So the two boys came up to my office. Well, let's come on up, we'll talk about it. I asked them what they wanted to sue the bank about. And they began to talk, and I let them talk and let them talk. And I said, well, I don't think you've got any cause of action there, and I'm not going to take that case. I'm not going to sue the Fort Worth National Bank. And one of them said, what do you mean you're not going to sue them? Says, you're our hired hand. You'll do what we tell you to do. I said, no. Says, you've got that wrong. So you can tell me when I can't spend your money, you can do that. But whether I'm going to try to handle this lawsuit or try this lawsuit, that's my business. I'll make that decision. So we sat there and sat there and sat there in my office and argued all day. And I finally told them, okay, just tell me when you want to bring your pick up your files, because I had a bank of files. So they did. They came in, brought their files, carried their files back, and then they started looking for another lawyer. And they went down to Lubbock to see my good friend Tom Milam, who is a heck of a good trial lawyer. You know Tom Milam well. You knew Tom Milam. We were good friends. And one day, Tom always kind of talked in a kind of a little high-pitched voice. And he called me, Thomas, he'd call me. And I phone rang one day, and he said, Tom, says, this is Tom Milam. I said, well, I know who it is, Tom. He says, I've got the Cogdell boys sitting here in my office, and they want me to represent them. So what can you tell me about them? I said, well, I'm going to let you make up your own mind about them, but I reached the point I could not represent them anymore. But they want to make the decision, not me make the decision. So he decided to represent them. I don't know whether he ever filed a lawsuit against the Fort Worth National Bank or not, but I got a telephone after about 6 months, got a call from Tom Milam. Tom says, this is Tom Milam. Would you take the Cogdell boys back? And I said, yeah, I'll take them back on my terms. If they won't let me handle the law business and them handle the money, I'll take them back, but otherwise, no. Well, they never did come back. Oh, well, I won't call the name. But the young lady was married to a rancher. I've got to call it. Well, anyway, her husband didn't like to make love at all. All he wanted to do was engage, and she liked to go off and have a little party every once in a while, go to town, not stay out on the ranch, and she liked to have a sip or two of whiskey, or maybe a beer, or a couple of highballs, and dance a little bit. And so he sued her for a divorce, and of course sought to take the children away on the ground that she was an unfit mother. Well, in the voir dire of the jury, one lady, I asked her if, I told her, just laid it out because it's part of the evidence, that now Flowers was her name, and I said, well, if Ms. Flowers like to go have a little party and have a drink or two every now and then, would you hold that against her? Could you be fair juror in knowing that? And she said, absolutely not. Said, any woman that would take a drink of whiskey is not entitled to raise those 3 little girls. We had 3 beautiful little girls there. She's not entitled to, well, I couldn't immediately I moved to disqualifier at that point. And the judge, who was that good judge from Papa I talked about, he said, "Now, Miss So-and-so, now you could sit here and listen to this evidence, and you could take the instructions from the court, and you could follow the evidence and the law, couldn't you?" She said, "Well, yes, Your Honor, I'd do the best I can." "Well, you're qualified." So he wouldn't disqualify her. So I had to go through all the steps that you have to do to protect yourself while to disqualify a juror, and I did. And the jury found she wasn't a fit mother, or awarded custody to her. I took it up to the Amarillo Court of Appeals, and Judge Chapman was a leading good judge on the court at that time. Well, he was, I hope I won't offend anybody, he was an Amen Corner Baptist, and he was a teetotaler. He thought the devil lived in a bottle of John Barleycorn.
John Barleycorn.
John Barleycorn.
Okay.
The devil lived in the bottle of John. Well, Judge Chapman wrote the opinion for the court, and he said he thought it was laudable that she would have that kind of an attitude, that he personally was not in favor of alcohol, but she absolutely could not be a fair juror, and the plaintiff was entitled to a fair jury, so reversed and remanded. Well, we got the case settled in, and my girl got the little girls. They didn't want to raise the little girls; they just wanted to spite her. So that was a really good story, I thought. And my family.
Yeah,
well,
wife, your children.
Let me go back all the way. I was one of 5 children. My dad and my mother lived in the Methodist church. My father was the superintendent of the First Methodist Church in my little town until he died. As long as I knew, he was, and we all went. My mother taught the ladies' Bible Sunday school class. We all went to church 3 times a day on Sunday. We went to morning Sunday school and morning preaching in the Epworth League in the afternoon. And if they could get us to go, we'd go to church again tonight, Sunday night.
This is the Methodist Church in Maypearl?
Maypearl, First Methodist Church in Maypearl. Well, I was baptized in the Methodist Church. I was joined the Methodist Church at age 6 years. Been a Methodist ever since. Haven't attended the church too much lately because I can't hear and I can't see, but but nevertheless, that was my family background. My dad was a pillar of the community. My brother and I, what we call meeting trains. We used to have, when I was growing up, we had 4 passenger trains a day in our little town. Remember way back in the 20s, that was the method of transportation, was railroads. We had 4 passenger trains a day, one south and one north. And 2 of them came through at night, so as soon as my older brother and I got old enough to what we call meet the trains, to take care of the tickets, take care of the express, take care of the whatever needed to be done, my brother and I did one. He met the night train, which was about midnight, and I met the morning train, which came at about 5 o'clock in the morning. So we did that from the time we were about 14, 15 years old. So we did that until we graduated from high school. But my mother was an angel, if there ever was an angel. My father was, if there's anybody close to St. Peter, he was close to St. Peter. They were just great. My brothers and sisters, everybody in the family got a college degree except one boy. He got married early and had to go to work outside. Make a living. So he went to work in a bank, as a clerk in a bank, and learned the banking business and became a good banker down the years. My older brother went to Texas Tech when it was a brand new school. He went to engineering school. He left in the Army, World War II, before the war started, became a major and he was had a black company, a completely black company. He was commanding officer of a 100% black company. And he had that black company all the way through North Africa and up through Italy. He got 2 Bronze Stars, and I don't know how many campaign mirrors. And all my other brothers, everyone almost went to the military in World War II. My sister, well, I couldn't say enough about her. She's just a lovely girl, beautiful little girl. And Dad tried to send her to the University of Texas, but after about 6 weeks, he said, I can't afford to send her. So he brought her back up home. But anyway, she's a wonderful girl. All of them are gone but 2 now. And but wonderful, close family. The family just, well, I'd say love was the word as far as our family was concerned. So that's the way we grew up. My wife, my dear wife, and let me stop just a moment and make, if I attribute whatever success I've had, I've got to give number 1 credit to my dear wife, Estella. She, when I was finishing up law school, she went to work for the Texas Health Department, worked all the time while I was finishing up. When I went to practice down in Harlingen, she went to work for the health department there. When I moved to Amarillo, she went worked for the health department here, and she worked until we had our first little girl. So I met my wife at the University of Texas.
What was her name?
Her name was Estella Garnett. She came from Spearman. She was valedictorian of her class in Spearman. She thought she wanted to be a musician. She was a good violinist. She won a state championship in typing. She was a really good typist, and she won state championship in that. So at the University of Texas, she was studying violin. She was living in a co-op house in those days, and I was living in a co-op house. And we put the 2 co-op houses together for a Sunday dinner one time, Sunday lunch, and that's where I met her. We struck it off pretty good. We got married in the middle of World War II.
So that was like in 44,
we didn't have any.
Or when was that? 1944, 1945? What year was it?
1943, middle of 1943. After I got out of the hospital, we got married that summer before I went back to flying.
Got it.
But she worked, and Lord, I couldn't ask for any more out of her. Well, we had 68 years of wonderful marriage, and she had a bunch of physical problems and was sick for about 6 years before she died, and died 6 years ago. So my daughters.
You had all daughters, no sons?
Have 2 daughters. My oldest daughter went to Texas Tech. She was good in art. She did real good in art in high school. She took art and got a Bachelor of Arts in art at Texas Tech. Then she went to the University of Wisconsin, got her Master of Arts and her Master of Fine Arts. All of this in studio art. And she met her husband at Wisconsin. He was in the art department there. She could not have any children. Diethylstilbestrol, which was given to her mother when she was carrying her. But she didn't go into art. She fell in love with golden retrievers. And she and her husband bought 2 golden retrievers, a male and a female. And she started studying the breeding of golden retrievers. And she's been at it for 37 years now. And she has built a pedigree. She's had 2 national champions, one at the Madison Square Garden. One is the #1 golden retriever in the United States for 1 year. Her dogs are all pure breeds dogs. It's just one of them. My younger daughter was an artistic also, but she was in the ballet world. She danced the Snow Queen in high school at Nutcracker. Then she just loved dancing, and she went into dancing and went to New York and Juilliard, and went to San Francisco Ballet, and then and she ultimately had her own ballet class. She also could not have any children, but she adopted 3 little Sioux Indian girls, full-blood Sioux Indian girls. Her husband was a quarter Sioux. He was a brilliant computer man. He's a mathematician and a crew. But anyway, they adopted these 3 little girls. So they're absolutely, well, it changed my mind about children. They're just as lovable as if they were my own, maybe more so. They're doing great. And the youngest one is, well, for oldest, my youngest one is number 1 in everything she does in she's in middle school now. My oldest one is made straight A's last term in junior college. The middle one is a mathematical genius, a pure math genius, just like her dad is. So a wonderful family. I couldn't ask for more. Had a happy family always. We've had close relations. Both of them play golf. I taught my wife learned to play golf. Of course, I became an adept at playing golf. And there's 100 good stories I could tell you about. I shot 79 at Augusta National, 79 at the old course at St. Andrews. Played Royal Troon, Muirfield, Carnoustie, Turnberry, Old Prestwick, Royal Troon, over in Ireland, shot Ballybunion. So it's been great. There's some of my golf pictures on the wall. I got my handicap down to 3 one time, and so I've
Never seen
survived.
anybody your age, frankly, that's as mentally sharp as you are.
97, going on 100.
I got it. 97 to remember the judges in the 50s and the 40s.
Yeah, I can remember them.
That's
I
astounding.
can call most of them by name. Some of the great friends, such wonderful men on the bench. Judge Charles Reynolds was just one of the greatest men that I ever knew. There's a half a dozen great judges. You just couldn't say anything except good about them. There's an awful lot of good lawyers, so many good lawyers that I've been good friends with and had a lifelong association with. And there've been a few, haven't been very many that I've been too crosswise with. I've maintained a good relationship even when we're fighting tooth and nail in the courtroom.
Sure.
And I think that's what you're supposed to do.
It is. Be a professional.
Okay.
Well, thank you for your time today.
I appreciate it.
Very enlightening and inspiring.
And again, I say I'm humbled by this honor.
Thank you.
Thank you.
It's good.
That was great, Tom.
That's good. So